Are you guys able to hear me? Anyone able to hear me? Okay, all right. So I'm just waiting for a few more people to join. So I will start at about 1:10 if that's okay with everyone.
Yes, miss.
All right, thank you. All right, everyone. I So we're going to begin now, and I'm going to ask if the host could allow me to share my screen, please. All right. So my name is Sandrine Morris. I am a third year student at the University of the West Indies, and I am majoring in law. So a little bit about myself. I would have done Cape Law in 2018 and 2019. It was one of my favorite courses. I got distinction in both years, and that was one of the many reasons why I chose to do law at university and why I chose to come back and to assist other students so that you guys can also get the grades. So that's just a little bit about myself. Heads up, this is not a teaching session. You guys would have gone from September to basically April, going through the syllabus with your teachers and exploring and getting the teaching and having the teaching learning process. And that would have been a lot of months compared to just one day or a few hours of going through both paper 2 and paper 1. And so I will not be able to reteach the course. What I will do is to go through some things that I think you guys may be exposed to show you how a student would answer the question, give you some tips, answer a few questions with you, and allow you to ask some questions. So that is basically what I'll be doing, because it is really a review session. So we'll mainly be going through some past paper questions. So I do hope that there is a clear understanding that I'm not reteaching the course. So let us get into it. All right, so for Unit 2, you guys would have gone through private law, and I am sure that you guys have been introduced or you know the difference with private and public law. Public law is what you would have done in Unit 1. And for public law, you would have gone through constitutional law, you would have gone through law and legal systems, you would have gone through administrative law, you would have gone through criminal law. That is public law, as opposed to private law, which deals with not necessarily, so public law deals with citizen and the state. And private law would have been, you would have seen that is between individuals or companies and individuals, etc. And it deals mainly with tort, contract, real prop, which you would have learned here in your CAPE syllabus, but it also deals with a lot of other things. It deals with family, with environment, with corporate, with company, private international law, and a plethora of other things that you will learn if you go on to study law in university, or if you go to any other faculty and you may be doing law and governance as a foundation course, or you may have to do business law as a prerequisite for something in social sciences rather. So wherever you go, you will be exposed to some form of law. And the majority of the times, the law that you will be introduced to is private law, which is why CAPE would have seen it, or CXC would have seen it necessary to have students introduced to both. It is my view that Unit 2 is somewhat slightly better than Unit 1, meaning Unit 1, you didn't really know a lot about law before. One of the modules in Unit 1 have about 8 topics simply because they're trying to get you used to law. But by Unit 2, by private law, you're mainly learning the principles of each area of law and how to apply them. So I really do think this should be, slightly better for you. I'm not going to say easier, but I'm going to say slightly better, given that you have already warmed your foot or you have already stepped into the water of what is law. Your exam format, you have 3 modules and you have 6 questions, 2 questions per module, and you will answer 3. So what you will only answer 1 per module. So you have 6 questions, 2 for each module, you answer 1, because the exams have been moved back to the original format. So last year and the year before, things changed a bit because it was COVID and they had released the broad topics, and so they would have probably changed the structure of the exam. But I don't know if I should say fortunately or unfortunately, you guys have gone back to the original module that I would have done and persons before me would have done. So the modules that you have law of tort, law of contract, and real property. Now, the topics that I'll be reviewing, I have negligence here and lease and license, but recognizing that I'll have to go through paper 1 as well, and we don't have that much time, I'm mainly just going to go through trespass against the person, misrepresentation, and mortgages. And the reason why I chose these topics, it's because, well, CSEC has a lot of topics that they give to you guys and that they give to students. And one of the things that they want to ensure is that they don't send students out into the world, everybody only focusing on the same thing. So for example, in module 3, they probably won't give you easements 5 years in a row or 3 years in a row, because they do realize that they have 4 other topics in that module, and students also need to know and read those topics. If you see easement every year, then you're just going to go ahead and study easement and you're going to leave the other courses, other topics in the module. So CXC finds a way to ensure that every year at least they give a new question under a new topic. And I would have seen where in 2019, I did negligence. And in 2000, for my module 1 question, in 2020, they didn't have a paper 2. In 2021, defamation was the broad topic. And in 2022, strict liability and vicarious liability was the broad topic. So what I would have seen is that it's been a while since a question came on trespass against the person and nuisance. I'm not saying, and I cannot say because I do not work with CXC, I can say that you're definitely going to get a question on trespass against the person and nuisance. But what I can say is to just take my advice and ensure that even if you study everything else, you are versed on these 2 topics, because since they haven't come since 2018, there is a strong possibility that trespass against the person and nuisance may come. For module 2, in my time, we got mainly contractual terms, and in 2021, they got formation and discharge of contracts, and in 2022, they got contractual terms, doctrine of privity, and illegal contracts. But misrepresentation has not come since 2018. So that's just a hint. I'm not saying study this topic alone, but it's just a hint. If something hasn't come since 2018, there is a possibility you might just open your paper and it is there. And for the final module, which is real prop, in my time, I got fixtures and chattels. 2021 was law of easements, and last year it was land ownership and co-ownership, which means mortgages and lease versus license, or lease and license. We usually say lease versus license because usually what you're asked to do is really just distinguish between the 2. Those haven't come since 2018, and that is concerning because it is my view, and if you have seen past papers, they do love mortgages. So the fact that mortgages haven't come since 2018, that is a hint that it may come this year. So again, I'm not saying to only study these, study as much as you can, but I would say focus on these topics since they haven't come in a while, and they want you guys to know these topics. So there is a possibility you might see them. So again, trespass against the person, nuisance, misrepresentation, lease and license, and mortgages. Just look into those because they may come. I don't work with sexy. I can't tell you if they will come, but there's a possibility since they haven't come in a while. Somebody raise their hand, Yolanda.
Good afternoon. What about consideration, miss?
Consideration came in 2019, but you can go over it because that's been a while. So you can go over consideration along with misrepresentation. But it's one consideration was one of the recent topics. So it might come,
Okay.
but
Okay, miss.
yeah. All right, so the types of questions that you will be exposed to, you'll be exposed to essay questions and problem questions. Now, tips for the essay. The A student will define all the key terms that you see, right? The A student will also ensure that if the question is on a case, you explain in full details the facts and the main principle dicta of the case, because there's no way you can talk about the case and you only give, there is a way to study cases. And I know we all have our cheat codes because we aren't about to sit down and read some 65-page cases. Well, you'll probably have to do that when you get to another level, but for now, you guys try to, use the study guide, or you use some other way of just trying to summarize these cases so that when you go into the exam, you can remember. If you see two questions and one is on a case and you don't know that case, everything about it, the rationale, the dicta, you don't really know the facts, you don't really know the principle, you don't really know, there's a judge that was a standout judge that said something on it and you don't know it, please leave that question alone. That is my advice, because you cannot talk on a case and don't know about the case. So if you see a question on a case and you don't know the case, or you see a line from a case that a judge spoke about, and yes, you know the line, yes, you were going to use it in your essay, but you don't know the case, please leave it alone. Ensure to look at whether the question speaks to Commonwealth Caribbean countries. You will get marked down if it's about Commonwealth Caribbean countries and you just constantly talk about jurisdiction is important. So if you keep talking about England and you use the English cases and whatever, it's not that you're not going to get marks for those. It's just that you're going to lose marks simply because you did not identify Jamaica or Trinidad or Barbados or a Commonwealth Caribbean country. If they ask for a Commonwealth Caribbean country, there's a reason for that. So please do not overlook it. Look at the marks allocated and write accordingly. If it says this question is worth 2 marks, you don't need to write 2 paragraphs because you're not going to get any additional marks than the 2 marks. And you're going to lose time that you could be using to do something else. Ensure that just a typical essay, you have your introduction, you have your points, but you put your points in paragraphs, you have your conclusion. It's still applicable to your legal essay, as I said. The only difference is that you now use your cases and statutes and legal textbooks as a guide. Tri-peel, this is something I learned from like high school. I think it works perfectly, where for each paragraph you have the point, you have an explanation of the point, which is usually your principles, you have examples, which are usually your cases, your additional cases, other than where you took the principle from, and you have a link where you connect the point to the question that has been asked. Problem question. So in unit 1, I have you were given more problem questions, but that's not what I should have put. You were given more essays actually, sorry, in unit 1 because of the nature of the topics. But in unit 2, because it deals a lot with private law, you will see a lot of scenarios and you're asked to advise a lot of persons. And so you may see more problem questions, or you may see a mixture of problem questions and essay questions, which is what I've seen a lot in the past paper questions, where you see a lot of things asking, you see a lot of questions where it says, define this or explain this at the top, and then you get a scenario in section B. So you might get a mixture of both. So you do need to know how to do a problem question. And I don't know if you would have learned this. I'm hoping you would have learned it. I would have gone through it last year in my session. If any one of you guys were in the Unit 1 session, and it's on the Unit 2 session is also on YouTube, I would have gone through it. And some teachers go through it because it is the ideal way of answering a problem question, and it is the only way you can answer a problem question in university. So problem question against essay questions, how do you actually tell the difference? So before I show you how to answer the problem question, I'm going to tell you how to tell the difference. Essay questions usually ask you to discuss, critically discuss, evaluate, examine. And I have an example here to say, critically discuss the doctrine of privity in a Commonwealth Caribbean country. While problem questions are usually presented in the form of a scenario, and it is usually laced, it's usually packed with legal issues that students must identify and answer using a particular method. Now, it also asks you at the end to advise a party or several parties. The method for answering a problem question is the IRAP method, which is issue, I for issue, rule, R for rule, sorry, A for analysis or application, anyone you would have learned, it can be used interchangeably, and C for conclusion. So I for issue, R for rule, A for analysis, application, and C for conclusion. Now, issues, these usually involve the legal problems that you have identified in your scenario. And it must have facts plus law. So it can't just be whether she walked down the street. It must be whether in walking down the street and whatever the legal problem that is in the question, that's what you're going to put there. Whether there's a legal issue, whether there's a legal problem that you have identified, rather, you must put it there. So there must be law, or whether you can connect it back to a statute, whether you can connect it back to the principle of a case, but there must be law for it to be a good issue. You can't just have facts. So yes, you have the facts of the case, but you must, where you see there's a legal problem, that must be in your issue for it to be a good issue and for it to be considered a legal issue. Principles involve all sources of law that connect to the issues that you have identified in the question. So if the Constitution applies to your issue, you take the section of the Constitution, put in your principles. If there's a statute, legislation that connects to your issue, you have to put that in your principle. If there's a case that applies to your issue, you have to put not necessarily the whole facts and everything of the case, but the juicy dicta, the principle of the case, the rationale of the case. If there's some special test in the case, that needs to be placed in your principles. So for example, the but-for test. So you would need to put that in your principle if your legal issue connects to the but-for test. Analysis and application. This is where students are expected to connect the principles above to the facts of the scenario in detail. And this is how you show them that you really know the law. So it's not necessary that you're going to rewrite the principles or anything. You're just going to show how the principles that you have listed above connect to the issue, the legal issue that you have identified. Conclusion. This is where you will just wrap up in a line or two at the end of your issue what you have identified in your application. So once you're finished, for example, your legal issue is whether his act raises some form of liability in negligence, then in conclusion, you're basically going to say, therefore, based on that and that, he is liable or he is not liable under negligence. But that is just your conclusion at the end of your issue. You also have to have a general conclusion at the end of answering the problem question in totality. And this is where you give the party specific advice on any remedies or anything available to them. So to make it a little easier for you to understand, if you have 4 issues, you will have 5 conclusions. You will have a small conclusion at the end of each issue of the 4 issues, and then you'll have a general conclusion at the end of the question. Any questions on that before I move on?
No,
All
miss.
right. So we'll get into module 1, and we're going to start with the law of tort, which, well, that's module 1. Now, just some backstory. If you're going to do an essay, if you have an essay on tort, you might want to know this. Not really essential in your problem questions, but if you have an essay, you might want to know this. And just to, get your foot wet a bit to understand what is tort. A tort here, according to Gilbert Colellini, from the Commonwealth Tort Law text, is it may be defined broadly as a civil wrong involving a breach of duty fixed by the law, such duty being owed to persons generally, and its breach being redressable primarily by an action for damages. So basically, tort aims to compensate persons for harm done to them wrongfully by another. Compensation here can be in the form of damages or an injunction. And I assume you guys understand what is an injunction, but just for persons who may not be familiar, an injunction is where the court would have made an order for something to be stopped or paused. So you can get damages or you can get an injunction. Now, the difference between a tort and a crime is important mainly because you might get some of these in your multiple choice questions. The difference between, we'd have learned originally at the start of the session that a tort would have been private law, and it would have been between private individuals, plaintiff and defendant, claimant, defendant, etc. So it would have been between individuals, while crime is between individuals and the state, so the DPP and the defendant. In tort, you get damages or injunctions, while in crime, in criminal law, you're sentenced to prison, jail time, etc. Tort protects the interests of the individual, while crime protects the interests of the public. So the aim of criminal law is to protect the public, while the aim of tort is to protect the interests of the individual. Tort against contract, they're both under private law, so you won't find that much differences like with tort and criminal law. However, with tort, the duties are strictly fixed by law, while contract, the parties actually fix the duties according to their agreement, but it's still subject to the law. So, essentials of tort law, and these are questions that you guys should always ask when answering a tort question. Whether the plaintiff suffered damage without legal injury, and whether the plaintiff suffered legal injury without damage. The reason why these are important is because you can't get a claim, or you cannot win a claim in tort if there's no legal injury. So that is called danum sine injuria, damage without legal injury. The principle is that damage is not actionable in tort unless the actions of the defendant amounted to a legal injury. Who determines whether there's a legal injury? The court. That is up to their discretion. Because if the matter is too trivial, if the rights and interests of the plaintiff aren't really violated, and considering the rights of the defendants and whether there are any defenses or anything, the court has to look into that to see whether there is a legal injury. The second thing is legal injury without damage, because the reason for tort is to compensate you for harm done. So if there's no damage, injuria sin damo, if there is no damage, then damage mainly to the person's property or to their reputation if we're talking about defamation. If there is no damage, even if there is legal injury, there will not be an action in tort. But some torts are actionable per se. So you have to consider, for example, trespass against person, especially assault and battery. So in that case, as an A student, while you're going to explain in your essay that, oh, there's no tort if there's legal injury without damage, please always remember that some torts are actionable per se. Area focus for module 1, again, will be trespass against the person. I will be focusing on false imprisonment and malicious prosecution because I have a session that is up from last year, still on YouTube, speaks to assault and battery. I don't think I want to go through assault and battery again because you can access that. And I believe for every session going forward, for every year, I'll focus on another topic so that whenever you students go on YouTube, you can see what you have a wide selection to choose from. So went through assault and battery last year. It may come on your exam. So my advice is to go back to YouTube and watch the unit 2 session from last year. And then you'll also have malicious prosecution and false imprisonment that you can go through. So the question that we're going through is Carla, a lawyer, is late for court and takes a chance to drive along the priority bus route, even though she has forgotten her pass at home. She's driving within the speed limit, and upon arriving at Pacrotown Junction, she is stopped by Inspector Showoff, who searches her car and arrests her despite her explanation that she must be in court by 9 a.m. Inspector Showoff orders Carla to accompany him to the police station for questioning, and she obeys. Carla is detained at the police station overnight and released the next morning. Inspector Showoff charges Carla for dangerous driving, but the case is dismissed. Carla comes to you for advice on whether she can succeed in an action against Inspector Showoff. A, define each of the following: false imprisonment and malicious prosecution. And B, advise Carla on whether she can succeed in an action against Inspector Showoff for false imprisonment and malicious prosecution, 21 marks. And A is worth 4 marks. So the A student would recognize that is 2 per definition, 2 for false imprisonment, 2 for malicious prosecution. Do not write 3 paragraphs defining false imprisonment and malicious prosecution. So it's a mixed question. You have somewhat an essay type, you need to just define, just plainly define, and then you have the problem question in section B. False imprisonment I have here, and I noted that you should pay attention to the allocated marks, which I would have explained before. You don't need to go into too much details. Usually if they want you to define with case, they will tell you to define with a case. So false imprisonment refers to any unlawful and complete physical restraint of another person's freedom of movement. And malicious prosecution refers to where the defendant maliciously and without reasonable and probable cause initiates against the plaintiff a criminal prosecution which terminates in the plaintiff's favor and which results in damage to the plaintiff's reputation, person, or property. I don't know if I need to explain this, but I'll still do it. The plaintiff is a person that is usually the victim, the one that usually suffers some form of harm, while the defendant is the one who usually initiates that harm. The issues that I would have identified for section B is whether Inspector Showoff's request for Carla to accompany him to the police station omits him from liability for false imprisonment. So there shouldn't be any and there. So whether Inspector Showoff's request for Carla to accompany him to the police station omits him from liability for false imprisonment. 2, whether Inspector Showoff can rely on the defense of lawful arrest. And 3, whether Inspector Showoff's act of charging Carla for dangerous driving while she was driving within the speed limit gives rise to an action for malicious prosecution. Sorry. So these are some examples of how you would write your issue with facts and law. Any questions so far?
No, miss.
Okay. So for issue 1, principle. Again, the issue is whether Inspector Showoff's request for Carla to accompany him to the police station for questioning omits him from liability for false imprisonment. So to show you how the principle is done, you give a basic start as to what is false imprisonment and what is the main or what are the main features of false imprisonment. So I have here, it is false imprisonment to detain a person even if no physical force was used, if there is the use of authority. And the reason why this principle is what I use is because this principle is usually the principle that is examined when it comes on to police personnel, because they may not have chained you somewhere, they may not have locked you up somewhere, but the fact that they ask you to, like, for example, accompany them to the police station, even though in this case she was arrested, even if you weren't arrested, that is still a principle that you use when referring to police personnel and them asking you to accompany them, because false imprisonment need not have any physical force. It just needs to know that the person have submitted to authority. I would have used the case Davis and AG, where it was held that if a police officer invites the plaintiff to accompany him to the police station, it will be false imprisonment unless the officer instructs the plaintiff that he can refuse to go to the station. Other principles that were examined are in Boston and Kirplanis Limited, where the judge held that there must be a complete restraint of the plaintiff, and if the plaintiff is not arrested and there is no authority used to lead him to believe that he's not free to go, then there's no action in tort for false imprisonment. So basically, this case was saying is one or two things: is either you arrest the plaintiff or the plaintiff had submitted to authority, usually out of fear. He further held that each matter depends heavily on the facts, and whether on the facts of the case did the defendant exercise restraint upon the liberty of the plaintiff. So you use that principle now to recognize that it depends really on the facts that you have been presented with in the scenario. In another case, Clark and Davis, I think this was a Jamaican case actually, it was held that when the plaintiff was asked to show the police his place of work and accompany the police to the barracks, it was impractical for him to refuse given the circumstances. It was noted that the court must assess whether the plaintiff was actually consenting or merely submitting. So whether the plaintiff really wanted to go to the station or whether they were just submitting because the police say you need to accompany and you have to accompany me. And if you don't accompany me, something is going to happen. Additionally, if it is proven that it was submission and there was no reasonable cause to detain the plaintiff, then there's an action for false imprisonment. In applying, so that's an example of principle. In applying the principle to the issues, I remember I told you that your application is basically connecting your principle to your issue. So again, the issue is whether Inspector Showoff request for Carla to accompany him to the police station for questioning omits him from liability for false imprisonment. In the application, I note in Clark and Davis, it was held that the facts of the case is what is important in making an analysis on whether there is false imprisonment. In assessing the facts of the current case and applying the principles above, the circumstances were such that Carla could not have refused to go. And in your application, you're going to say, no, why? Why is that the inspector asked her to accompany him to the station after he arrested her. The facts at no point in time stated that she was advised that she could refuse to go, as was explained in Davis. And unlike in Boyston, in this case, there was an actual arrest rather, before the request. So she could not move. Similarly to the facts in Clark, the plaintiff was not presented with any opportunity to refuse as she was arrested and could not move, as I said earlier. Additionally, as was the case in Clark, the plaintiff was restricted with no reasonable cause, as the inspector did not reveal that anything was found in the vehicle and the plaintiff was driving within the speed limit. And if you guys want to use some principles from the procedures of arrest and the fact that he should have informed her why he was arresting her, none of that was done. So you can use that in your application. Conclusion, remember I said you will have a conclusion after every issue. So concluding this issue, based on the application of the principles to the facts of the current case, in advising Carla, she can bring an action in tort against the inspector for false imprisonment. Why? As by arresting her and not telling her that she could refuse to accompany him to the police station, he restricted her movement in every way. Right? So that is a way of answering the first issue. Any questions? All right, so we'll go to the second issue. Issue 2, whether Inspector Showoff could rely on the defense of lawful arrest. I have the principle here why this is even a question in the first place. The reason why this is a question is it is because it is a defense to false imprisonment if the defendant can prove that the restraint upon the plaintiff was lawful. Now, lawful arrest, you want to give, assume that your examiners don't know anything about lawful arrest, don't know anything about trespass against a person. You want to just give a quick little explanation that lawful arrest can be with or without a warrant. Sorry. However, since as he had no warrant here, and that is clear as day, you don't need to go into what is arrest with a warrant, because that's not what it's asking. It's not an essay, and that's not what your legal issue is based on. So again, you get marks for identifying basic stuff, but you don't get marks for writing 2 paragraphs on something that the question is not asking about. So you need to focus more on arrest without a warrant. So for arrest without a warrant to be lawful, you want to put the common law principles. And then I also have statutes there because you know that legislation in Jamaica overrides the common law. So at common law, a police officer or a private citizen must prove that a person who is in his presence commits a breach of the peace or so conducts himself in a way that causes a breach of the peace to be reasonably apprehended. Section 15 of the Jamaica Constabulary Force Act notes that it shall be lawful for any constable without a warrant to apprehend any person found committing any offense punishable upon indictment or summary conviction and to take him before a justice. I also use cases there because usually cases interpret statutes and it helps you a lot better. And so because the statute don't change every day, but cases update every day and helps you to understand the statute. So you want to put cases. So here I put common law, I put statutes, and I put cases. That is something that the A student would do. So I use the case Walters and W.H. Smith and Son Limited, where it was held that a police officer may arrest without a warrant even if a felony has not been committed. If he can show reasonable grounds for suspicion. The test for reasonable suspicion, so I put another case there because I have the principle if he can show reasonable suspicion, but then you're going to go into your application and be like, was there a reasonable suspicion? Because you don't know what is reasonable suspicion. And word of advice, don't put anything in your application that is not in your principle. That's why the IRAP method is there. It's to show you have an issue, you have the principles, and you're not just connecting your principles to the issues. So you can't put a case in your application or put something new in your application because then you can't connect, because all you're supposed to do is connect. So you need to put everything that you think you will need in your principle if you want the full marks. And trust me, the principle is where you get the most marks because this is where you put the law. Principle and application, gold. Now, so I put the test for reasonable suspicion so that your examiner can understand that, well, when you go into the application, this is how we'll know what is reasonable suspicion and whether it existed in your facts. So the test for reasonable suspicion is explained in the case Dallison and Caffrey, where it was held that the test is whether a reasonable person who knows the law or has the information that the police officer possesses would believe that at the time of the arrest, there was a reasonable and probable cause for it. Now in the application, in the current case, one must assess in accordance with Section 15 of the Constabulary Force Act, as well as the principle in Walters, whether Carla had committed a felony or was about to commit a felony in the presence of Inspector Showoff or any other citizen, or whether in accordance with the principles of Dallison, the reasonable person having knowledge of the law or the knowledge that the inspector have would believe that at the time of Carla's arrest, there was reasonable and probable cause for same. On the facts presented, the plaintiff Carla was driving her vehicle. So this is how you're going to apply now the rule to the issue or to your facts. On the facts presented, the plaintiff Carla was driving her vehicle within the speed limit when she was stopped by the inspector, who then searches her car and did not indicate that he found anything to be suspicious. However, he proceeded to arrest the plaintiff. In applying the principles to the facts of the case, the inspector does not appear to have any reasonable suspicions or probable cause on which he arrested the plaintiff. Neither was the plaintiff engaged in any activity that would threaten the public, and the reasonable man with knowledge of the law is likely to believe that the arrest could not be justified. And in conclusion, on these grounds, in advising, because remember, a question said you should advise Carla. On these grounds, in advising Carla, Inspector Showoff could not rely on the defense of lawful arrest. Any questions before I move on?
No, miss.
Okay, all right. So section B, issue 3, principle. Issue 3 is whether Inspector Showoff's act of charging Carla for dangerous driving while she was driving within the speed limit gives rise to an action for malicious prosecution. Now the principles of malicious prosecution which apply here. In the case Ramkisoon and Sorius, it was held that an action for malicious prosecution, or it was held that in an action for malicious prosecution, the onus is on the plaintiff to show that the prosecution was unjustified. However, the case Wills and Viacine is the case which lays out the principles governing this tort. In this case, Wooden CJ held that the plaintiff must show that the law was set in motion against him on a charge of a criminal offense, or that the prosecutor instituted the prosecution against him. Additionally, he must prove that he was acquitted of the charge, or that otherwise it was determined in his favor. Further, he must prove that he was prosecuted without reasonable cause and with malice. And then there's another case that explains the test in detail. The test for what is a reasonable cause was examined in the case Hicks and Fuller, where it was held by Hawkins J. that the test would an ordinarily prudent and cautious man placed in the position of the accuser come to the conclusion that the person charged with was probably guilty of the crime imputed. And in Glinsky and McIver, it was agreed that this test is objective and it is correct. However, they also added a subjective test to say whether the defendant honestly believed that the plaintiff was guilty. And then malice here does not refer to just ill will, but rather in Brown and Ox, Cave J explained that malice is any wrong or indirect motive, and malice can be proved either by showing that the motive was and that it was wrong, showing what the motive was and that it was wrong, or by showing that the circumstances were such that the prosecution could only be accounted for by imputing some wrong or indirect motive to the prosecutor. I think that would have been to the accused rather. So we're doing this application together because I've done the last two for you guys, and this is really a review session and I want to see where your brains are at. And so what we're basically going to do is just take the facts, and see if it matches the principle. That's all you're doing. And I want you guys to get this so that when you go into your exam, you know what you should do for your application. You're basically just going to take your facts and see if it applies here. So the first thing we're going to look at is, according to Wood and CJ, whether the prosecutor, which in this case was Inspector Showoff, whether they're the ones who, or whether he's the one rather, that set the charge against Carla. The answer is yes, because he took her to the station, he detained her, he locked her up, he charged her. That's what the facts said. So given that we see that, no, you can proceed. The second thing is that you must prove that the case was acquitted or that it was determined in the favor of the plaintiff. This is just a question, you guys can answer me, because I said we're doing this together and I feel like I'm still leading and still going through. Was the case acquitted or determined in the favor of Carla?
Yes, it was acquitted.
Acquitted,
Yes.
miss.
Acquitted,
Yes.
miss.
Yes. Okay. So that was in favor of the plaintiff. So he charged her, but it didn't go any further because the case was acquitted. So that is another part of the test that has been satisfied. So we can now move on to look at reasonable and probable cause. So he said that the plaintiff must prove that he was prosecuted without any reasonable or probable cause and with malice. Now, what is reasonable or probable cause? That's why I have the next test there, which is Hicks and Fuller. And Hawkins J said the test for probable cause or reasonable or probable cause is whether whether an ordinarily prudent and cautious man placed in the position of the accuser or the officer in this case would have come to the same conclusion that the person charged was probably guilty of the crime imputed. And Glinsky says whether the defendant himself honestly believed that the plaintiff was guilty. So now you're going to go back to your facts to say whether use yourself now. So forget about the inspector, forget about Showoff. You as let me get some names. You as Aliyah or as Ches or as Crystal, just you as a person, as an ordinary person, would you believe that Carla did something wrong or did a crime where she needed to be arrested?
No, miss.
Okay, and you use a subjective test too. Could you as a police officer, if you place yourself in the police officer, honestly believe that she was guilty? And if you say yes, you honestly believe that she was guilty, then you're gonna have to give reasons for your answer.
No, I don't think she was guilty based on the facts that we saw in the question.
Okay, all right. So you need to explain that in your application, you have to explain those facts to say, well, she was driving within the speed limit. He found nothing in her car. The fact that he actually detained her and then he charged her and for dangerous driving, which driving within the speed limit and dangerous driving don't really match. It don't really make much sense. So you have to put that. So you're going in your application, you have to use your facts. You have to use up your facts. So you can't just say based on the facts of the case. So you're going to have to explain what are the facts of the case. And you're going to say, well, he charged her for dangerous driving and there was no dangerous driving. So you have to explain that in your application. And on that case, or in that situation, you can now say you have established the principles of that test in your application and you can move on to malice. Malice, as explained by KJ, it does not refer to just ill will, like somebody say a malice, them you just don't like them. It doesn't refer to that. It means to rather wrong and indirect motive, and you must prove that the motive was wrong. Were his motives wrong? Why did he arrest her? He didn't have probable cause to do so. He charged her for something that was not there. So it was wrong. It was a wrong motive. He had no reason to do so. You'll have to explain that in your application. So that is how you apply. And then you will conclude here to say that based on you going through all of the things that Wooden CJ would have said, he did not satisfy the test. That's the inspector show off. And so there is an action, or it gives rise to an action for malicious prosecution. And then you do a general conclusion where you're now going to conclude everything that you would have found in false imprisonment and malicious prosecution. Tell her that basically, he is liable for false imprisonment, or there may be, you might want to use the words may, because that helps you a lot, but or you can be solid and select a point, but if you want to be neutral, I think that is great that there may be an action for false imprisonment and malicious prosecution, and you need to also tell her the remedies that are available to her, whether she has a remedy, whether damages are available to her as a remedy, or anything else that is under false imprisonment and malicious prosecution. So you want to research in every topic that you're doing towards what remedies are available. Well, in every topic that you do in private law, in contract, also in real property, what remedies are available, because you need to put that in your general conclusion, and you need to advise Carla. So in conclusion, in advising Carla, based on the application that you would have done, Inspector Showoff there's a possibility he's liable for false imprisonment and malicious prosecution, and the remedies available to her are, and you continue from there. So that is the end of that question. Any questions from you guys? Okay, all right. And
Promise.
Okay, go ahead.
No, Mr. said no.
Oh, you
I
said
said
no.
no.
Oh, okay. All right. Great. So, and I'm not going into nuisance, but I gave a tip that you guys should study. Yolanda?
Actually, again, so basically, in order to gain those 21 marks, you must give cases and remedies, and look on both possibilities where whether he or she is wrong, why it would have been implied, how this could have been implied, or the other way of doing it, and explaining it basically in order to gain those 21 marks.
Yes, that's correct.
Okay.
Mhm. I'll also send my slides to you guys so that you can look back at the IRAP method for some assistance when studying studying for your exam or going through other past paper questions. So I have here a tip for nuisance, which I would have told you before. Study nuisance in detail and heavy on the private nuisance, because most of the questions with nuisance, or all of the questions with nuisance, have a private nuisance question. So heavy on private nuisance, study nuisance, because it has not come since 2019 and since 2018, and it's just in my head that you might see that. You may or may not see it, but study it. Negligence also, because that haven't come since 2019. So if you want 3 topics to really focus on, I would say trespass against a person, nuisance, and negligence, since the others came last year and the year before. By no means is this a case where I'm telling you not to study defamation, please, or strict and vicarious liability. Please study them, but please go over them, but take my advice. They came last year and the year before, so they may not come again. The others have not come in a while. I'm going to give you guys a 10-minute break, so we resume at 2:14, where we'll go to contract. All right, welcome back. Just give me a second to share my screen. All right, are you able to see my screen?
Yes, Miss.
All right, great. So we're now going to go into okay. So we're now going to go into the law of contract. If that break was too short, then I will try to give you a few more minutes on the second one so that you can get a better bathroom and water break. So I'm sorry if that break was too short. So we're now going to go into the law of contract. And as I said before, we're going to focus on misrepresentation. I'm not, by no means am I telling you guys to go in and study this alone. Obviously, you're going to get 2 questions. So you might get another question on another topic. But I know that misrepresentation is not particularly one of the easiest things, and it hasn't come in a while, and it may come. So I'm just going to go through it. All right, so fast paper question with reference to at least one decided case. Explain each of the following: fraudulent misrepresentation worth 4 marks and negligent misrepresentation worth 4 marks. I hope you guys see the difference. In the previous question, the Tort question, when they just wanted the definition and no case, you realize those definitions, it was basically 2 marks each. But in this question, where they want you to give a case, you see where it's 4 marks. So you know you're going to have to put the case to get a little bit more. And so again, it's a mixed question again. So you have the first part, which is somewhat an essay type, and then you have the section B, which is going to give you a problem question. So section B, Mary tells Nicole that she intends to open another branch of her beauty salon and wants Nicole to be her partner. She takes Nicole to a shopping center and points to a shop which she says she has rented already. Nicole sees some men inside the shop doing renovations. She wants to take a look, but Mary tells her not to worry as they can come back another day. She also tells Nicole that she can see the rental agreement whenever she wants. Nicole gives Mary $2,500 to assist her with the opening. 6 months have gone by and Mary has not opened the new branch. Nicole then discovers that Mary had never rented the shop. With reference to at least one decided case, advise Nicole whether she can recover her money. And that would have been, hold on, give me 1 second, please. Let me just look back at this question. All right, so this question is worth, so the section A is worth 8 marks and section B is worth 17. I should have put it there. I do apologize for that. So misrepresentation. So just to give you a blanket definition of misrepresentation before you go into what is fraudulent and negligent misrepresentation, misrepresentation speaks to where a statement is made in a contract that is often untrue and it induces one of the parties to join the contract. There are 3 types of misrepresentations: fraudulent, negligent, and innocent, but you are required to focus on the first 2. Fraudulent misrepresentation, and the leading case or the locus classicus is Derry and Peak, and you can look directly at what Lord Herschel said, and he defines fraudulent misrepresentation as circumstances where a false representation has been made knowingly or without belief in its truth, or recklessly without caring whether it be true or false. In other words, this is a statement made by one party who does not honestly believe it to be true, but it was still made with little regard to the fact that it may be dishonest. Negligent misrepresentation, on the other hand, I use the case Headley, Byrne, and Co. against Headley, Byrne and Co. and Hello and Partners Limited. The House of Lords in this case held that negligent misrepresentation is where one party makes a statement that is not necessarily fraudulent, but simply careless. You should not have made it, especially if you have expertise in that area, you should not have made it. That's basically what it's saying. And because I know negligent misrepresentation may be a little more confusing, I use another case as an example, to just buff up the 4 marks, because the definition is literally like 2 words. So I use another case to just give it some body. And it's basically an example. So I use the case Esso Petroleum Co. Limited and Marda. In this case, the plaintiff Esso granted a lease to the defendant Mardan for a filling station, gas station basically. Esso had 40 years of experience in the field, and instead of relying on those 40 years, they advised Mardan that, because they basically want to sell him the station and they kind of want him to pay it, so they tell him that the estimated throughput of the filling station in its 3rd year of operation would be approximately 200,000 gallons. Unfortunately, after those 3 years, it was only 86,000 gallons, and it affected Mardan, and so he couldn't pay his rent. Esso, the persons who misled him, decided to sue him for arrears, but he countersued, noting that he relied on the statement that they provided. He relied on their misrepresentation because they are in the business, they've been in there for 40 years. So if somebody, for example, if a doctor come and tell you, a doctor of like 7 years come and tell you that your bone is fractured, you're more likely to believe the doctor of 7 years than you're going to believe a medical student, right? So it's not that you're saying that the medical student don't know what they're saying, but you're going to basically just think that 7 years you've been working in this business, you should know what you're saying. So if you tell me that the wall is blue, I'm going to believe the wall is blue because you have had experience here. So basically that's what they were saying. That's what Martin was saying. Esso had 40 years of experience and he relied on them before entering on their statement before going into the contract. The court agreed with Mardan that there was a special relationship between Mardan and Esso, as he really believed their statement to be true. And he relied on their 40 years of experience that they have in the field when he decided to follow that statement. The court held that by advising him wrongfully, Esso breached the duty of care that they had, and thus they are liable for negligent misrepresentation. So that is what negligent misrepresentation is. Fraudulent is saying it, say it wrong, basically. I hope using the Jamaican vernacular is fine. Fraudulent, say it wrong. You still say it. And I rely on that. That's fraudulent misrepresentation. Negligent, no. You were just careless. You have expertise in this. You have sense about this, and you still tell me this. You were just being very careless. Any questions on fraudulent, on what is fraudulent misrepresentation, what is negligent, or what is negligent misrepresentation? No questions, so we'll move on. Section B. Mary tells Nicole, again, just so you can, refresh your memory, because we've gone through section A, you might not remember what was said in section B, so just to refresh your memory. Mary tells Nicole that she intends to open another branch of her beauty salon and wants Nicole to be her partner. She takes Nicole to a shopping center and points to a shop which she says she has rented already. Nicole sees some men inside the shop doing renovations. She wants to take a look, but Mary tells her not to worry as they can come back another day. She also tells Nicole that she can see the rental agreement whenever she wants. Nicole gives Mary $2,500 to assist her with the opening. 6 months have gone by and Mary has not opened the new branch. Nicole then discovers that Mary had never actually rented the shop. So with reference to one decided case, advise Nicole whether she can recover the money. The issues that I found, whether Mary's statements to Nicole informing her of the opening of her new shop and her invitation for her to be a partner, knowing that the shop did not exist, constitute fraudulent misrepresentation. Whether Mary's statements to Nicole induced her into entering the contract. Whether Mary can rescind the contract on the grounds of fraudulent misrepresentation, and whether Mary can be awarded damages in lieu of fraudulent misrepresentation. Principle for the first issue. I used again the case Derry and Peak, which I used to explain fraudulent misrepresentation. Again, it's the locus classicus case. So not because you refer to it already, you're not going to refer to it again. It's the locus classicus case. If you're going to answer a question and it's the locus classicus, you have to use it again. So Lord Herschel in Derry and Peak defines fraudulent misrepresentation as circumstances where a false representation has been made knowingly or without belief in its truth, or recklessly without caring whether it be true or false. Additionally, and because I'm not just defining it here, because I'm trying to answer an issue, I included other things that Lord Herschel would have said. Additionally, he explained that in a claim for misrepresentation, there must be a false representation of fact, which may be word or conduct. The representation must be made with the knowledge that it is false and that it must be willfully made in the absence of the belief in its truth. The false statement must be made with the intention that the claimant should act upon it, sustaining damage in so doing. And so we're not going to match, or in our application, we're not going to connect the principles here to our facts to see whether it answers the issue. So, application and conclusion. In applying the principles above to the issue, Mary had informed Nicole about the opening of her new shop. And she even requested for her to become her partner. She went as far as to show Nicole the space that is the supposed shop. And she told her that she could even see the lease or the agreement to put it in the actual terms that were used. On this basis, or on the basis that Mary knew that this shop did not exist, or this space that she showed Nicole was not actually hers, this was false representation of fact, in connection with the principles which Lord Herschel would have laid down. And also, she willingly made these statements to Nicole, knowing that it was not true. Further, the statement was made to Nicole with the offer of her becoming Mary's partner. And this shows the intention, in my view. You may have another view, but in my view, if you're going to show me and tell me that I can see the lease and you're going to ask me to become your partner and you're going to say you're going to open the shop, you have an intention for me to become your partner, so you have an intention for me to act upon the fraudulent statement, because I need to become your partner for the shop that you're going to open that does not exist. This, in my view, concludes or sums up the principles of Lord Herschel, and thus, since he said these principles confirm fraudulent misrepresentation, then therefore, based on the principles of Derry and Peak, the contract here may be between Nicole and Mary may be voidable because it consists fraudulent misrepresentation. I never put void, I put voidable. And you'll learn
Miss,
further. Go ahead.
Miss, could we say that it was this statement that induced Mary into the contract?
So the thing is, because that is issue number 2, that's why I didn't really put it so much in issue number 1. So when we go to issue number 2, then we'll discuss further whether it was actually the statement that induced her. So if you have more than one issues, you don't want to make your problem question monotonous, sorry. So you can give a hint, like here, where I would have said that, you know, her intention was for Nicole to act upon the statement, but you probably don't want to give too much. And then when you go to issue 2, you already spoke about everything in issue 1. So you want to be careful. Because that's why, let me show you. You might want to, on your exam paper, write out your issues like this so that you don't become monotonous. So you know how to answer each before you actually answer the question. So you might want to do that. That's just food for thought so that you don't, keep repeating yourself. That's it. Any other questions?
Miss, are you saying that we should list out the issues first? My audio cut out.
Yes, so you can do that. So you can do that if it helps you to not keep repeating yourself.
Okay, Miss.
Yes. All right, so issue 2, whether Mary's statements to Nicole induced her into entering the contract. The test in principle, the test in Derry and Peak is not enough to allow the plaintiff to recover. The court must also be satisfied that the fraudulent statement induced the plaintiff into entering the contract. So the reason why I put this is because remember the test in Derry and Peak was basically just asking whether, the statements were fraudulent. But now we need to know whether the statements induced her into entering the contract. That is how you get to whether she can actually get back her money. But the test in Derry and Peak is not enough. So you have to go to Atwood and Small, which is one of the cases that helps with answering whether the party was induced into entering the contract, or what is a test to see whether the party was induced into entering the contract. So in Atwood and Small, the Earl of Devon held that if the innocent party failed to take any reasonable steps to ensure that they were not being deceived, they cannot rely on misrepresentation. So basically, Atwood was saying, if you never checked to see if that was really her shop, then you cannot claim misrepresentation. But this was overruled. So you want to show steps. That is how the A student or the A+ student or the 1 straight A student comes about. You want to show where the law is coming from and where it is now. So you talk about Derry and Peak, say it talks about how whether the statement is fraudulent, but that is not enough. So you go to Atwood, which says that you need to take steps to ensure that this was not misrepresentation. But then Lord Halsbury, you want to show the position of the law now, which is Lord Halsbury, and that overruled Atwood. So Lord Halsbury in Aaron's Reef and Twist, he explained that under equity, it is not sufficient to say that a person who is induced by false representation ought to have used due diligence to find out that it was untrue. And you know that equity comes about, to reduce the harshness of the common law, right? And you would have seen where Atwood would have been really harsh and really hard for the innocent party. So Lord Halsbury is basically saying that you don't need to do that. You just need to prove that it induced you. You don't need to find out whether they were telling the truth or not. But to go further in how you can apply your principles, Bevad Limited and Human, this is a Jamaican case, and you would probably love this, especially if the question tells you about a name Commonwealth Caribbean country. Harris J.A. in this case stated that what is relevant is that one party made the false representation and the other party in deciding whether to enter the contract relied on this representation. So we're now going to apply our principle mainly to see if if Mary made a representation and whether Nicole relied on this representation rather to enter the contract. So doing this together, and I'm basically just giving you some pointers because time is against us and we want to do mortgage and do paper one. So pointers, so basically I'm asking what you think. Pointers I have here, her statements made Nicole want to look at the shop. Nicole, when she said, I want you to be my partner, when she said, she showed her the space, Nicole wanted to look at it, and she knew it wasn't her shop. So basically she was there, probably coming up with these, when she said, like you just trying to have somebody believe something. So you're going to say, you don't have to look at the shop, no, but you can look at the lease if you want. You can look at the agreement if you want. She was doing that to Nicole. And after she did all of this to say, I want you to be my partner, she took her to look at the shop. She told her she could look at the agreement. It was after all of this was done that Nicole gave her her consideration. It was after all of this that Nicole gave her her $2,500. And you also have to look at whether the statement was made before or during the contract, because misrepresentation, inducing you, must happen before. And we would have seen, according to Harris J.A. in the Jamaican case, and we would have seen where this was made before the consideration, before there was any execution of any contract. And it was basically, again, after looking at the shop and after her convincing her that she can look at the agreement, that Nicole gave her the money. So in my view, I don't know, you have to make your own application, but in my view, it was the statements made and her conduct that caused Nicole to give her the $2,500. And so in conclusion for me, go ahead, Yolanda.
Miss, personally, even though it is fraudulent, right? But I think Nicole was negligent at some point, because even though she said you don't have to look on the shop, but here are the documents, I think she could have looked on the documents and say, well, look whether it is right to even compare it more, because yes, it is fraudulent based off the facts that are given in this scenario, but she was negligent on another behalf as well.
Thank you, Yolanda. And I'm glad you made that point, because I'm going to go back to my principle to show you why I had a case there, Atwood and Small. So remember in Atwood and Small, basically Earl Devon is agreeing with you, where he's saying that the innocent party need to take steps to see that they were being deceived. But then that was overruled by Lord Halsbury in Aaron's Reef. So this is where the principle becomes important in your application. So you remember when I was telling you guys earlier that you have to put every single thing that you're going to need in your principle, even if you don't see how it is so important. Once it is connecting to your issue, you need to put it there, because then you'll come back to this and then you're going to say, but wait, I don't have a case to really explain it. So that's where it's important. So you can use Atwood, but then you have to also still remember as the A student that Atwood is actually overruled by Aaron's Reef. Aaron's Reef said, no, you don't need to do that. You just need to prove that you relied on this and it induced you into the contract.
Okay, man.
You're welcome. 1 second. All right, so issue 3, whether Nicole can rescind the contract and recover damages as a result of the misrepresentation. A misrepresentation makes a contract voidable, not void, because a misrepresentation does not end the contract. The contract is still in force, but it turns the contract into something where the misrepresentee, that is who you call the victim or the person that is affected, can decide to rescind, or basically what rescind mean is to revoke the contract, end the contract there. Once the contract is rescinded, then it becomes terminated. So you want to explain that clearly. The A student will explain that a misrepresentation does not void a contract, it makes it voidable. So it puts it in a position where it can become void. And once the contract is rescinded by the misrepresentee, then it becomes terminated. N, no more. Rescission is available for all types of contract. However, the misrepresentee must communicate with the other party before rescinding the contract. So basically, in this case, Nicole would have to communicate with Mary before ending the contract. Additionally, he or she, which in this case would be Nicole, would lose the right to rescind if they had full knowledge that the information was false and still proceeded with the contract, or if there was a lapse in time. So basically, she didn't know. But if she did look and if she did do her investigation, as you said before, Yolanda, and did her proper investigation and find out, if she did find out and then still went through with the contract, then she could not rescind it. But if she didn't know, then she can rescind. So I hope that's clear. And if there's a lapse in time, basically, what lapse in time means is that you didn't come as soon as you find out. So she waited how much months or how much years or anything of the sort before she decided that she was going to come to the court and try to rescind the contract. You could no longer do it. This is explained in the case Leaf and International Galleries, where Lord Jenkins, or where Jenkins LG at the time, noted that the representee must either verify or disapprove the representation within a reasonable time, or else they have to stand by the decision with the stand by the contract, or just let it fall by it, let it end, suffer from a bad judgment. Additionally, if it is impossible for parties to return to the position that they were before the contract was executed, then rescission will be lost. This was explained in Spence and Crawford, where Lord Wright noted that if the events or activities occurring since the date of the contract had made restitution impossible, for example, goods have already been consumed and cannot be replaced, then there can be no rescission. So you need to look at all these principles now and see whether they apply to your facts. Question, do you think Nicole can rescind the contract? Somebody, go ahead. Do you think she can rescind the contract? Was there a lapse in time? Go ahead.
I think she can rescind it, miss.
Mm-hmm.
Because there wasn't a lapse in time, miss, because when she realized that there was no sharpness, because she never, to my assumption, she never investigate before. So I went to the day I went to go for like check out our shop or support, she realized that there was no shop there. So I think you can resend the money.
Okay, all right. And the last question that would be here, because you already answered the lapse in time part, and you also answered that she did not know. So the last thing that I would ask anybody is that, do you think it's impossible for restitution? Is it impossible for them to go back to where they were before? And give reasons for your answer. So remember, I had said in this principle that impossibility refers to, for example, where there were goods and the goods were already consumed, and so you can't get back the consumed goods or the already consumed goods, so you can't rescind the contract because you can't go back to where you were before. Is that the case with the facts that we have before us?
Yes, the goods would have been the money, right? In this case, right?
Yeah, so in this case, the only thing she did was give the money. So there was no shop, there was nothing. So is it impossible for her to go back to where they were before, where she get back her 2,500?
Well, if there was no shop, so that means that the money was not being used.
Right.
So that means that she can get back her money because there is no shop legally.
So I agree. So there is nothing there. There was no profit or anything. Somebody sent something in the chat. So, Ches, right. So it is not impossible. She can go back to.
Yes.
Go ahead.
I think it is important to also note that with misrepresentation, contracts are voidable and not void. So they
Yes.
need to work through it.
Yeah, so we went through that. So continue.
No, miss, that's it.
Oh yeah, so we had noted it in the principle that it makes it voidable and not void until the affected party decides to rescind the contract. And the last issue that we have is whether she can recover damages from Mary for the misrepresentation in the contract. Where there is a fraudulent misrepresentation, the representee, which is a affected person, can claim both rescission and damages. However, as it relates to damages, a tort measure is applied in attempting to restore the representee to the position that they were before the execution of the contract. And remember, we would have said a while ago, where they were before is that she had her $2,500. Additionally, in Doyle and Albee, it was held that recovery of damages for consequential loss caused by fraudulent misrepresentation is not restricted to loss which was foreseeable, but extends to all actual damage directly flowing from the fraudulent inducement. And the damage would have been, or anything flowing from it would have been she losing her $2,500. And it also, I guess, speaks to profits and if anything would have been there. And so that is really a case for the courts to determine whether she should just get back the $2,500 or whether there was more money that she could have gotten because she lost, because she was expecting the 2,500 to multiply and there was no shop or anything like that. So that is basically a question for the court. But I do believe she can recover damages, and I believe she can specifically recover her $2,500, but you can also advise her that she can take legal action where the court can settle or the court can decide whether there is more that she can get in damages. Any questions? All right. So that is it for misrepresentation and for contracts. And I will give you guys a 15-minute break this time. So you'll come back at 3:03. Oh, there's somebody typing in the chat. Oh, Ali, I miss you mentioned something about the Commonwealth Caribbean countries. I didn't get it. Can you explain again? All right. So basically, I was talking about a Jamaican case where Harris J presided over. Give me 1 second. Bevad and Oman. So I was saying that is it's good to be versed in misrepresentation cases or tort cases, contract cases, tort cases, real prop cases that deal with the Caribbean. I'm not saying you have to know 10 cases from the Caribbean, no, but I'm just saying it's good to be versed per topic, but I'm just saying it's good to be versed on them because you may get questions that speak to Commonwealth Caribbean countries. And it don't make sense to answer a question about a Commonwealth Caribbean country and you just pack it up with other cases or international cases. So it's good to have at least one in there that speaks to a Commonwealth Caribbean country if the question asks about a Commonwealth Caribbean country. You're welcome. All right, so come back at 3:04 then, guys. So you get an extra minute.
Wait, excuse me, miss.
Yes?
You mentioned something earlier about we can reuse the locus classicus cases more than once during a question.
So, well, in this case, what happened was that it has two sections. So it has section A, which is a essay question, basically. And the case was used to explain, because it said you should use a case to explain fraudulent misrepresentation. So I used the locus classicus case there, but then we come back to fraudulent misrepresentation in our first issue. And so you have to use the locus classicus case again. So you can use it 2 times if it's something like that, or if the question is structured like that.
Okay, Miss. Thank you.
You're welcome. So 3 or 4, guys.